The best of money matters. The Big Story.
Welcome to The Big Story. I'm Hongbin Jeong. Ong Beng Seng has pleaded guilty. The 79-year-old tycoon, best known for bringing Formula One to Singapore, admitted to helping ex-Transport Minister Mr Iswaran cover a 5,700 business-class flight from Doha. The payment was delayed for months and only made after anti-graft investigators spotted Iswaran's name on a flight manifest during a separate probe. Mr Ong also had a second charge taken into consideration for offering flights and a hotel stay to Iswaran, knowing he had official dealings tied to Mr. Ong's business interests. This comes just weeks after Mr. Iswaran was released early from jail, having served part of his 12-month sentence. Court sentencing is expected to return on August 15th at 2:30 p.m. So what's at stake and what happens next? Joining us to share more is Associate Professor Mervyn Cheong of the National University of Singapore and Deputy Director at the Center for Pro Bono and Clinical Legal Education. Hi, Professor Cheong. Welcome to the show.
Hi, Hongbin. Hi. Thank you for having me.
Thank you so much for joining us. Well, Professor, what charges did Mr. Ong face in court today? What did Mr. Ong plead guilty to?
Mr. Ong faced two charges in the state courts today. He pleaded guilty to the first charge of abetting the obstruction of justice. And Mr. Ong's second charge concerned abetting Mr. Iswaran to accept gifts in his official capacity without any payment. This second charge was taken into consideration for purposes of sentencing, which effectively meant that Mr. Ong admitted to the commission of this second charge as well.
Well, in the Singaporean context here, how big are these or severe are these charges?
In the context of Singapore, these offences are severe because it affects the execution of public duties, and ultimately these two charges that Mr. Ong faced, one concerning the obstruction of justice and the other one is sort of the giving of gifts that would affect the performance of a public duty in the form of Mr. Iswaran's ministerial duties.
Well, according to the defense here, Mr. Iswaran was the prime mover while Mr. Ong had momentary involvement. How is this distinction crucial in the context of this case?
This distinction is relevant in the context of this case because Mr. Ong is charged with abetment offences, which by definition involve more than one party. So in such cases, the court must consider the relative culpability of each participant. So if the court accepts the position that Mr. Iswaran was the prime mover behind the offences and Mr. Ong's involvement was momentary, then Mr. Ong's blameworthiness may be considered significantly lower. This then has direct implications for sentencing because under the principle of parity, the court aims to ensure consistency in sentencing among co-perpetrators, but parity does not mean identical sentences. If one party played a leading role and the other a subordinate one, the court may impose different sentences to reflect the different degrees of culpability.
Well, given Mr. Iswaran's 12 months jail time, how might Mr. Ong's sentence compare here?
Mr. Iswaran received a total of 12 months imprisonment for 5 charges to which he pleaded guilty. However, when comparing sentencing in Mr. Ong's case, it is important for us to focus on the specific charge that overlaps, which is the charge concerning obstruction of justice. For that charge alone, Mr. Iswaran was sentenced to 4 months imprisonment. In Mr. Ong's case, I understand from the news that the prosecution indicated that it would have sought an 8-week sentence. So if we just isolate the prosecution's sentencing position without factoring in mitigation consideration like medical issues, Mr. Ong's sentence should still be expected to be lower than that of Mr. Iswaran's.
Well, on February 7th, it was reported that Mr. Ong was receiving treatment for multiple myeloma, a type of blood cancer. Now, his lawyers urged the court to exercise judicial mercy and impose a fine with no prison time. So, Professor, what is judicial mercy under the Singapore law and how common is this used in Singapore?
Judicial mercy is the court's discretionary power to impose a much more lenient sentence than it would have because of exceptional circumstances. It is very rare. To date, there have been only 2 situations in which judicial mercy has been exercised. First, where the offender is suffering from a terminal illness. And second, the offender is so ill that a sentence of imprisonment would carry a high risk of endangering the individual's life.
But how does it differ from the more common consideration of ill health as a mitigating factor during sentencing?
The key distinction lies in the legal basis and purpose behind the court's consideration. In a 2020 decision, the Singapore Court of Appeal reaffirmed that judicial mercy is grounded in humanitarian considerations. It is exercised only in exceptional circumstances where there is a compelling reason to depart from the usual sentencing framework out of compassion. This reflects the idea that in rare cases, the suffering caused by punishment to the offender may be so severe that it outweighs the public interest in punishing the offender. So by contrast, there is a separate and more common sentencing consideration where the offender's ill health does not justify judicial mercy, but instead affects how the principle of proportionality is applied. If incarceration would cause the offender significantly more hardship than it would an average person because of that offender's particular medical condition, the court may adjust the sentence to equalize the impact. So this is, in the second scenario, it is not an act of mercy per se, but a recognition that justice requires punishment to be proportionate to the offender's circumstances.
Okay, well then given the legal framework we've just discussed here, do you think Mr. Ong's situation met the threshold for judicial mercy? Is this a fair judgment made by the defense?
I think based on what has been reported, it appears that the technical threshold for judicial mercy could be met because Mr. Ong is said to be terminally ill and imprisonment may pose a serious risk to his life. That appears to satisfy the conditions under which the court can consider exercising its discretion for judicial mercy. But I think the more difficult question is whether the court should exercise that discretion. As I mentioned earlier, judicial mercy is grounded in humanitarian considerations, but it is only justified where the suffering caused by punishment would be so severe that it outweighs the public interest in punishing the offender. So this is where the context becomes important. Mr. Ong's case is not an ordinary one. The circumstances involved a former minister and marked the first public sector corruption court case involving a cabinet minister since the 1970s. I think that raises significant public interest concerns, particularly around accountability and deterrence. So I think while the defense may be justified in raising judicial mercy as a ground, whether it is ultimately fair or appropriate for the court to grant it will depend very much on a careful balancing of Mr. Ong's personal circumstances against the broader public interest in upholding accountability and deterrence.
Well, if Mr. Ong had not been in poor health, then do you think the outcome or prosecution strategy would have changed?
I don't think the prosecution's overall sentencing position would have changed. Their position was slightly guided by the nature of the offence as well as what they submit Mr. Ong's level of culpability to be. I think what would likely have been different is the set of mitigating factors before the court. Without the medical condition, Mr. Ong would not have had ill health as a basis for seeking a lighter sentence, and the defense will have to rely on other mitigating considerations, if any, such as his cooperation during investigations. But I think the prosecution's baseline position on sentence, in terms of the length of the custodial term, would probably have remained unchanged.
Well, Mr. Ong Beng Seng's sentencing will take place on August 15th. So how much do you think he'll be fined, or is there still a chance for him to face a jail sentence as well?
The offence that he has pleaded guilty to does not a maximum quantity of the fine that can be imposed. However, the jurisdiction of the district court is such that it can only impose a maximum fine of $30,000. And according to the news, it's not clear whether a specific number has been suggested to the court. But with all that said, it is an issue. I had mentioned earlier that the court still needs to consider whether it should exercise judicial mercy. And even if judicial mercy is exercised, it can well be in the form of a very much shorter imprisonment term instead of a fine as well. So there is still a chance for him to face a jail sentence.
Okay. Well, then does this mark the legal closure of the case as a whole? I mean, are there likely to be further legal ramifications for Mr. Ong or any others involved?
Once the court decides and announces the sentence on the 15th of August, it would not be the end yet, because both Mr. Ong and the prosecution will have a right to file an appeal if either party is not satisfied with the decision. They will have 14 days from the 15th of August to make that decision. If there is no appeal filed, then the matter will truly have come to a closure at that point in time.
Okay. So before we let you go here, Professor Cheong, then what precedent does this case set for how business leaders engage with public officials now?
I think this case will show that business leaders will have to be very careful in our dealings with public officials. I think while in the last year or so, much of the focus has been on how public officials need to conduct themselves, I think business leaders probably have to put themselves up to a very similar standard as well in terms of transparency and accountability in their dealings with public officials. Even if they happen to be long-time friends, I think they still need to have proper documentation, transparency and accountability, especially when items of certain value, or even though we are in an Asian society where meals are quite common, I think those have to be properly disclosed and accounted for as well.
Some great insights from you there. Thank you so much, Professor Cheong, for joining me today.
Thank you for having me.
Thank you. That was Associate Professor Mervyn Cheong of the National University of Singapore and Deputy Director of the Center for Pro Bono and Clinical Legal Education. This has been The Big Story with me, Hongbin Jeong.
To listen to more great interviews, download our podcasts at audio.sg or download the audio app. That's AWEDIO, audio at the App Store and Google Play.